Our next session is Adjudicating Construction Arbitration Claims, the Asian Perspective. May I request the chair and the speakers for this session to please come onto the stage. Please. Sir, please. Complexity of documents involved in construction contracts, coupled with long life cycle of a construction project, offers a breeding ground for disputes. Post-COVID, claims have gone up for reasons attributable to pandemic, such as shortage of labor, unavailability of raw materials, supply chain issues, etc. The panel through this session shall talk about issues surrounding adjudicating construction claims in arbitration and the possible ways of maneuvering through the same. It gives me immense pleasure to introduce the chair to this session, Honorable Mr. Justice Deepak Gupta. Justice Gupta obtained his law degree from Delhi University in 1978. He practiced in the High Court of Himachal Pradesh and was appointed Judge of the Himachal Pradesh in 2004. He remained acting Chief Justice of the High Court of Himachal Pradesh twice. He has been the Chief Justice of the High Court of Tripura and Chief Justice of the High Court of Chhattisgarh before being elevated as a Judge, Supreme Court of India in 2017. With Justice Gupta, we have Mr. Julian Bailey, Mr. Ratan Singh, Senior Advocate, and Mr. David Thomas. Mr. Julian Bailey is a partner in the London office of Jones Day. He advises on international construction and infrastructure projects across a variety of industries. He is actively involved in construction law issues and was chairman of the Society of Construction Law UK in 2015-16. He is also the author of Construction Law, which is one of the leading books on construction law. Moving on to Mr. Singh. Mr. Singh is a senior advocate and an arbitrator based in New Delhi, having 25 years of experience with specialities in construction, engineering, infrastructure, mining, and general commercial and civil disputes. He has also been involved with the industry players and stakeholders through his chairmanship with the Society of Construction Law India and directorship of the Chartered Institute of Arbitrators India. He is also a member of the Keaton's Chamber. Moving on to Mr. David Thomas. Mr. Thomas has been consistently recommended as a leader in his field. He has also been nominated for Construction Silk of the Year in 2013 and 17 at the Chambers and Partners Bar Awards. He has been instructed in some of the biggest and high-profile cases in the world. He is a regular Court of Appeal advocate and frequently appears before Technology and Construction Court on high-profile matters. He has also provided long-term advisory work in relation to landmark developments around the world. With this, I request the chair to please take the discussion forward.
A very good afternoon to all of you. See, the topic is adjudicating construction arbitration claims, the Asian perspective. I don't know whether we'll get an Asian perspective, but from an Indian point of view, I am no expert like the three speakers here. I'm still on the learning curve, trying to learn. But despite being a novice, the bread and butter in arbitration in India is construction arbitrations. Because I think more than almost two-thirds of the arbitrations one deals with are construction arbitrations. And we need to develop construction jurisprudence with an Indian perspective. I have found in my last 3 years working as an arbitrator and handling some construction arbitrations that we normally blindly, and that's the word, blindly follow the Emden or the Hudson formula without even seeing what the evidence is. The basis has to be the evidence and not the formula. The formula will follow only on the basis of the evidence. The other aspect which I have noticed is both in awards as well as in judgments of courts, with due respect to the judges, that once a delay is proved, an award is made without even thinking whether that delay has effectively actually delayed the construction of the project or not. You see, you get 2 years to complete a project. There may be a couple of months delay in getting environmental clearance or the right of way, but that 2 months delay may not end up in 2-month delay in completion of the project. It may only lead to a delay of a week or 10 days. There are overlapping claims. A lot of times in the arbitration world, especially in India, I find that overlapping claims, the degree of overlap is not being looked into. And we are awarding claims under different heads without looking whether one head overlaps the other. Because in this period of 2 years, there could be delays under separate counts, but many of the delays would be overlapping. So you can't award for all counts. Therefore, I look forward. So these are the issues I want to flag as to how do we deal with them. Another aspect with regard to the formulae which we apply, these formulae have evolved in the Western world in a totally different environment of construction as well as of finance. There, the labor rates are much higher than in India, and in India, construction is very labor intensive. That's a big part of the labor cost. Another aspect is our inflation rates, our interest rates are very different from those in the Western world. This is a thing which actuaries actually should be doing and giving an idea of what is to. This is not something which lawyers or even engineers can do. So we have to develop our own system, our own construction jurisprudence. And Mr. Ratan Singh, being one of the leading counsel on the construction side in India, I think he has a big role to play in that. MoRTH, the Ministry of Road Transport and Highways, has laid down certain guidelines, but those are limited to cases of the NHAI and are not being followed elsewhere. But again, there also there is a lot of overlap. So I hope the three speakers will enlighten us on these aspects also. I know they have prepared a powerful PowerPoint presentation, and they're working as a team. This is very unusual. I find that they're working as a team and they're doing a joint presentation in a sense. So I think this will be a nice experience, and therefore without much ado, I shall hand you over to Mr. Ratan Singh, who's going to start off on behalf of the speaker. And a big thank you to David and Julian for coming to India to help enlighten us on this topic.
Good afternoon. I'm Miller Justice Gupta, David Thomas, Mr. Julian Bailey. Before I share my thoughts on what Miller Justice Gupta said, first about this joint presentation. David happens to be my chambermate in Keating Chambers, London. We belong to the same chamber. Julian happens to be an old friend, and I'm his great admirer of his book. 15th to December to 2nd of January, I was in London. I had meetings with David and Julian in a French restaurant with good wine, and we thought about it, and we thought about this presentation and this joint presentation, and this is how it comes out today. But before we start with our joint presentation, some of my thoughts about what Miller Justice Gupta said, because this is something very, very important issue which has been flagged. And this is what generally intelligent chairs will do. They'll flag issues and the other panelists have to deal with them. Thank you, sir. First of all, this formulae, there's three notorious formulas globally applied for unabsorbed overheads and lost profit on account of lost opportunity to the contractor because of the prolonged stay over a project. That is what leads to claim for unabsorbed overhead and lost profit. This has its origin, as Miller Justice Gupta said, this has got its origin in Western world. Hudson and Emden evolved in UK, Esley evolved in US, and this is how it is used in these respective jurisdictions. Now, Miller Justice Gupta has very rightly pointed out that this is one of the most hot controversy and dispute in arbitrations between the competing parties, employer and contractor. Contractors would invariably argue that since there is prolongation in the project, therefore as a result of which I am entitled to claim for unabsorbed overhead and lost profit, and therefore what I am supposed to do is I am supposed to use one of these formulas. And they will refer to McDermott's judgment of Honorable Supreme Court 2006 judgment of Miller Justice S.B. Sinha, authored by Miller Justice S.B. Sinha. Interestingly, this same judgment is relied by the employer as well as the contractor. Contractor says, I am not supposed to prove any loss. I am not supposed to prove any lost opportunity. I am not supposed to prove that I could not avail other opportunities which were available to me because my resources were stuck with this prolonged stay in a project. What they say is, Supreme Court has recognized that one of these three formulas should be accepted, so I'll just put the numbers, bring the numbers and fit in these formulas. Ladies and gentlemen, this is a wrong understanding of that judgment. This is what Miller Justice Gupta says. What you need to understand is, the genesis of this lies in Sunley judgment. Sunley versus Canard, this is 1940 Kingsman judgment of UK. Then comes Alfred Alfred McAlpine, that is 1995 judgment of UK, BLR, reported in BLR, very widely reported. Comes another judgment, that is Norwest-Horst judgment. This is 1998 judgment. Interestingly, two of the judgments are referred in to Indian Supreme Court judgments. Bharat Coking Coal judgment of 2004 refers to Sunley, and McDermott judgment refers to Norwest. However, Bharat Coking Coal judgment of 2004 very categorically says in paragraph 24 that you must prove loss first. You must prove that you have lost opportunities. Your resources are here lying idle probably or occupied in this particular project, but you must show that you had other opportunities which you lost. However, interestingly, in McDermott judgment, Honorable Supreme Court, Justice Sinha's bench, says that Bharat Coking Coal does not apply to the facts of the case of McDermott and moves ahead and recognizes these formulas. But somehow, the judgment is not very clear on the liability side. It only talks about quantification. We have to understand these formulas are only meant to quantification. So first of all, you have to establish liability of the employer. For that, you have to prove losses suffered by the employer. Unless that happens, you cannot go and claim the monetary compensation, if one has to really understand this. But interestingly, as I said, McDermott judgment refers to Norwest. So therefore, anybody who has to deal with this overhead, unabsorbed overhead issue and lost opportunity, what you should do is just take out this Norway's judgment and five ratios laid down and five tests laid down in that judgment answered this whole controversy, which in fact, Julian's book refers to that. And I referred in one of my very recent arbitration, Julian, you wrote a book on that. That's why I'm a great admirer of you. Now, if you really want to conclude this issue, then in that case, you have to read judgment of delivered by Melody Justice Vakru in IGM Gayatri versus NHAI, which very categorically says, unless you prove lost opportunity, in other words, you had opportunities, you could not avail those opportunities, but for your resources being stuck with this particular project. So that was one issue. Another issue what Melody Justice Gupta highlighted was that if there is delay of 1 month in giving the approval or right of way, question is actual delay may not have happened for 1 year. If it is 1 year delay may be for say week, 10 days, or maybe 2 months or 3 months. And what is being suggested by my chair is that you may have overlapping delays. And those delays which were encountered by the contractor may not be critical delays. That is what is coming from my honorable chair. I'll deal with this issue in some detail, but before that, may I just give you some background issues on that, about the construction law. You all know, as again, Justice Gupta said, almost 3/4 of arbitration in India are construction arbitrations. ICC report says that 40% of their arbitrations are construction, oil and gas arbitration. This is what ICC Paris says, the world's most reputed international arbitration institution. Now, question is, are we dealing with this construction arbitration the way it should be? The way this industry has evolved, the way disputes have come up, the construction legal industry has not evolved. That's my first reaction to it. In fact, just before COVID, I was speaking in Singapore in a construction law conference, and I was asked 3 questions. And first question was, do you teach construction law in India, in your law school or in engineering colleges? Second question was, do you have construction legislations like Housing Grants Act you have in UK, or SEPA, the last in the row in Malaysia? So these are security of payment legislations which really secures payment to the contractors, which really secures that there is a smooth execution of the project, contractor is paid, and this is how security of payment legislations have gone from places to places. Housing Grant Act was the one act. Then Singapore, as I said, Australia has it, New Zealand has it, Singapore has it, Malaysia has it, 22 states in United States have got security of payment legislations. Now, question is, are we having construction legislation in India? Again, answer is no. And third question, which was asked to me in Singapore was, do you have a specialized construction courts like you have TCC in London or in many other jurisdictions? So to all the 3 questions, whether we have construction legislation in India, whether we teach construction law in India, or whether we have specialized construction court in India, ladies and gentlemen, answer to all the 3 questions very negative. What we need to do is, we have to create awareness amongst all stakeholders, starting from project managers, contract managers, contractors, lawyers, arbitrators, and judges, that construction law is a different breed of animal, which was said by a very famous federal judge in United States of America. You may have that slide. He says construction law and construction arbitrations are a very different breed of animal. Therefore, it needs to be treated differently. It is not just law of contract or law of tort or any other such law which we read every day here. For that, I'll just move on to my slide. So before that, may I give you show you this slide, history of construction. 6000 BC in Bronze Age, building technology utilized clay, mud, bricks and timber. 3000 BC, development of fire brick technology. 2500 BC, emergence of cut stone construction. 1400 to 1800 BC, iron began to be used in construction. And 100 BC, development formula for concrete formation and glass technology. Construction is very old. And so is construction law, ladies and gentlemen. 1750 BC, when Hammurabi Code was written, which is the first ever codified law anywhere in the world, there was a construction law written, though slightly differently. It was an eye to eye era, and this is how it was written. If a builder builds a house for someone and does not construct it properly, and the house which builds falls in and kills its owner, then that builder shall be put to death. Eye to eye era, but you had a law. If owner's son dies, contractor's son will be dead. This is what that is old law on that. Evolution of construction law, that is something very interesting. I would urge all of you to give some thought to it. Around 200 BC, 10-volume treatise of Marcus Polio, renowned Roman architect. This is 10-volume treatise on construction law. And chief architects and architects in those days were the most important stakeholders in any construction anywhere in the world. Up till 19th century, architects assumed the role of a master builder. Thereafter came the age of subspecialties for different disciplines of construction. And construction law, now this is important, and this is what I would like you to have a look at. Construction law owes its modern recognition as a separate field of law to the judiciary's acceptance of doctrine of contextual context, and wherefrom you get the context. You have to therefore fall back on the industry. You need to know the industry, how this industry works, and this is where getting to know about peculiarities of the industry, you have to interpret the contract, and this is how developed implied obligations apart from express obligations under law as well as in the contract. And Paul Hardman versus Arc Power, US Federal Court observed construction contracts are separate breed of animal. This is what I was referring to. It is not merely advanced contract law, that is sometimes the critic would say about the construction law. Even well drafted, this is very important. Second row, it says even well drafted contracts are rarely complete in all respects. You see the internationally recognized construction contracts which are called standard forms of contract. Though problem in India is, though we claim that we are using those standard forms of contract, sometimes you say that it is red book which I am using or yellow book I am using, but the way employers are tweaking with those standard contract forms, that only red or yellow remains, everything else is strict. That is the day when you invite problems for yourself, rather you invent disputes for yourself the day you tweak with the standard forms of contract, because by tweaking what you are doing is, what are these standard forms of contract which is very prevalent all across the globe? These are prepared by all stakeholders who will be ensuring that risks are evenly allocated. Risks are taken by those who can really take those risks. So allocation of risks, getting to know about the rights and obligations of the parties, the moment you start tilting the balance in favor of the employer, it is hazardous. You are inventing disputes for yourself. And even though the standard forms of contract are never complete, so therefore you may have to think about industry best practices, international best practices. You will have to refer to implied contractual understanding and custom and uses of the trade, and that is why this is a separate breed of animal. This is another region why it is not only law of contract. These construction disputes, construction arbitrations or litigations are fact heavy, documents heavy, issues heavy, and you may have millions of documents because in any construction contract you may have thousands of documents which get generated on day-to-day basis, and these are long-term contracts running into years together. So therefore, managing those volumes of documents is a challenge, not only challenge for the contracting parties, it is equally a challenge for arbitrators like my chair sitting here, and I do sit as arbitrator. We also deal with this, but there are ways to deal with those voluminous documents. I may have to throw some light on that, but this is what is peculiarity of this. One construction arbitration is equivalent to sometimes 20 or 30 typical commercial arbitration. So you have to treat it differently. Custom and practices unique to the construction industry, that is what called domain knowledge one must be aware of. Now, this substantial performance is one concept which is very peculiar to construction contracts and construction projects. That is when, let's talk about EPC contract, where a contractor is able to substantially perform the contract, thereafter they get what they have worked for minus what they have not worked for, but if it is not substantial performance, he gets zero. Julian, you will agree with me. Next is the doctrine of economic waste. This economic waste doctrine I had used once when I was representing one multinational company against one state government, where issue was that under the contract it was for the rural electrification. Thousands of villages were to be electrified, and what had happened was, under the contract, as per the contractual specification, 48 inches of grouting was needed for erection of every pole, whereas contractor had done only 42 inches. They said, therefore it is a breach of contract. They terminated the contract, and they said, came out with a huge counterclaim saying that you will have to uproot all of these poles, and thereafter you have to re-erect this, so therefore everything falls on your head. And this is where I had used this doctrine of economic waste, and I had said, so long as this particular erection of poles are able to take the strength of the load of the cables, it is enough. Yes, if the contractor has saved some amount of money, you will get compensated for that, so you can have restitution to that effect. Otherwise, you cannot ask the contracting party or the contractor to remove all of this and re-erect all of this. Now, formulas of office overhead, you will not find this kind of formula anywhere in any other dispute. And you will have to also understand this formula. This is the first thing which Justice Deepak Gupta talked about today. These formulas have its region because it is very difficult, it is very complex to really establish and quantify this loss of opportunity and unabsorbed overhead. In order to take care of this complexity, these formulas got evolved, and this is how we are dealing with this. This is again very unique to construction industry and construction law. Thereafter, you have complex critical path concepts, and this is what Lord Justice Deepak Gupta was referring to. Now, please appreciate, in construction industry, every delay, or in construction industry and for all the stakeholders, every delay is not delay. And one may laugh at it. Delay is delay. No, I'm sorry. Every delay is not delay. When we talk about delay, what we are talking about is only those delays which are on the critical path of the project, which are critical delays, or in simplest possible expression, only those delays which delay the completion of the project are the delays. I repeat myself, only those delays which really delay the completion of the project are the real delays, are the critical delays, and only those delays entitles the contractor to claim, to have this prolongation claims. One has to understand the difference between delay and disruption. Disruption is all about loss of productivity. There may be certain events caused by the employer, But if that delay is not delaying the completion of the project, in that case, it is just a case of loss of productivity, and therefore, loss of productivity claim or disruption claim can be lodged by the contractor. Causation and compensability, unusual varieties of contract pricing arrangement. It is very unique to construction project. You have various kinds of and various types of construction contracts, different design standards, construction risks such as unforeseen site conditions, scheduling and coordination of, like the scheduling. I'll urge everybody sitting here in this auditorium, whoever has any interest in construction law or construction arbitration, first thing they should know about is the scheduling. I'm not saying that you have to become scheduler to understand the scheduling, but at least you should be in a position to read the baseline program. Like every commercial lawyer is asked to at least know how to read the balance sheets. Similarly, all construction lawyers or the arbitrators should be aware or should know at least how to read the baseline program. What are the activities written there? What are the milestones written there? What do you mean by start date? What do you mean by finish date? What do you mean by logic? What do you mean by sequencing? So these are the first basic things which everybody should know. Now let us take an example. A particular contractor says, you delayed for 100 days. For that I could not do this particular activity, and therefore you are liable to compensate me for 100 days of delay. Now why can't contractors say, why can't employers say, as per the baseline program, you had to in any case take 50 days to do that particular activity? If that is the case, as per the baseline program, so delay would be only of remaining 50 days, not of 100 days. That is the first principle. But these first principles simply get lost. And I have a particular slide which I think will be more important to talk about. And that slide talks about various kinds of delays. And I must tell you, all of you, that if as a lawyer or the arbitrator, if we are able to only think about this particular slide and be aware of what this slide means, that takes care of 90% of problems of every arbitrator or every lawyer when it comes to delay determination. And what is this? This talks about various types of delay. So first of all, I'll talk about excusable delay. This for anybody who deals in construction industry, for them it is very usual thing to know, but for construction lawyers and arbitrators, this is something important we must talk about. Excusable delay is the delay caused by the employer. So contractor is excused. Now, non-excusable delay, if it is excusable delay, contractor is entitled to have extension of time. But if it is non-excusable delay, that means it is contractor's delay, he is not entitled to extension of time or compensation or damages. Compensable delays, even assuming that employer has delayed, therefore it is a case of excusable delay, but what contractor is entitled for is, he may be only entitled for EOT and not for damages. There can be a situation where because of delays on the part of the employer, contractor is only entitled to extension of time to complete the project, but no damages, because you may have, and it is notorious in India, and not only in India, in many other jurisdictions where you have got no delay damages clauses. No delay damages clauses simply says that even if employer has delayed the particular execution of the project, that does not mean that contractor will be compensated for damages. It is very prevalent even in CPWD contracts. You used to have this kind of clause. So EOT, he gets EOT, but he doesn't get damages. You have non-compensable delay. A non-compensable delay I have talked about. Then is critical delay, and this is what every construction professional must be aware of. You have to think of what is critical delay, read as much as you can, and I'll just give you an example, maybe it can solve some of your problems. Let us assume that a four-storied building is to be constructed, and you as an employer have to approve the drawing for that whole building. Now, if you do not approve the building, if you do not approve the drawing for the casting of the slab of the ground floor for 4 months, surely contractor cannot move ahead and construct further 3 floors, because such a delay would be taken as a critical delay falling on the critical path. Now, what happens if the employer had not granted approval of a window panel on the ground floor for 4 months? In typical scenario, contractor will come, he will say, hey, you have not granted me approval for 4 months, grant me extension of time for 4 months, give me compensation for 4 months. In this example, such a simplified example, now your answer would be, hey, sorry, you don't get this, because even if I had not approved it for 4 months, you had to complete those entire building. Did you do that? Were you ready to do that? If you haven't done that, yes, this non-critical delay could have become critical delay if after whole building was complete, and because of this window panel, contractor was not able to hand over the project. So long as that stage is not achieved, it is not critical, it was non-critical. And this is how contractor, the employers or engineers have to approve the EOT applications to identify what are the critical delays, and only then you can identify this. And concurrent delay, that is another thing which, again, coming from Justice Deepak Gupta's the comments in the beginning. Here, there are 2 categories of delay I'll talk about. There is something called parallel delays, and there is something called concurrent delay. Concurrent delays are the delays which are caused by both the parties, contractor and the employers, during the same period. But again, when I say delay, concurrent delay, then it means critical delays. So concurrent critical delays caused by the employer, caused by the contractor during the same period, having the same potency, are called concurrent delay. Now question is, if it is a case of concurrent delay, how it is to be dealt with by the employer, engineer, or by the arbitrator. For concurrent delay, contractor gets entitlement for extension of time to complete the project, because that concept of hindrance from the side of employer comes in. That is basically called prevention principle. But let us forget that. Concurrent delay, since both sides delayed, therefore contractor would be entitled to extension of time. But now question is, will he be entitled to damages as well? This is where you need to consider and consult SCL delay and disruption protocol. I represent SCL in India. I founded SCL India in 2014, and I have been chairman, and I have been talking about SCL delay and disruption protocol. I will encourage all of you sitting here, if you are having anything to do with construction industry, construction practice, or arbitration as arbitrator or lawyer, you must have this SCL delay and disruption protocol, as you have been keeping CPC by your side as a litigator. This deals with all aspects which generally comes before us as lawyer, as arbitrator. It deals with all of this, and SCL delay and disruption protocol talks about concurrent delay, and SCL delay and disruption protocol recommends that if it is a case of concurrent delay, contractor is surely entitled to extension of time, but at the same time, he may be entitled to damages if he is in a position to demonstrate that he incurred some extra cost for the delay event caused by the employer, not for the delay event which was caused by the contractor himself. Therefore, for concurrent delay, it is very uncommon to see claim for damages coming from the contractor side, because it is a very, very nuanced. Only if your documentation is very nuanced, you can really establish that this is the difference between the cost which I would have otherwise incurred because of my fault and cost which I have incurred because of employers' delays event. I think it is going too much of nuance. So before I move ahead, one thing we must understand that for construction industry, for all construction stakeholders, one thing you should always remember is that good record keeping is the key. Good record keeping, again, what are the categories of record? Every lawyer must know if you are a lawyer, if you are an arbitrator, what is that you do in construction dispute? You are essentially recreating the whole project before yourself by way of referring to the pleadings which come before you. So as a contractor, as a lawyer, or as an arbitrator, what we do is, as a construction lawyer or construction arbitrator, is we are recreating the whole project before ourselves. And in order to recreate everything, what you need to do is you have to look at what are the documentation. Therefore, proper record keeping, as mentioned in SCL Delay and Disruption Protocol, Appendix B, Julian, that tells you what are the categories and types of records which parties should really keep for themselves. Now, if you are aware of the categories of record keeping, which is really happens in construction industry, that helps you immensely also in getting to know what documents you should ask for during the course of discovery. So what my suggestion to everybody sitting here is, if you have to do anything with the construction industry and construction arbitration, you must know what are the documents which parties really maintain. If you know what are the documents parties maintain, you can ask your clients to produce those documents. Arbitrators can ask the parties to produce those documents. The litigating, both sides, disputing sides can ask each other to disclose those documents in discovery. And this is how whole project can be recreated. So that is another thing which I was talking about. So these are basically the various types of delays. If you are aware of various types of delays, I am very sure we will be able to understand. And I'll tell you what happens. The role of experts is very, very important when it comes to construction dispute, construction arbitration. Now, what you should do is, whenever it is a case of delay, now you need to have sometimes, or you need to have the delay experts. And what these delay experts do? These delay experts will identify what are the critical delays. In other words, what were the delays which were falling on the critical path? Identification of critical delays is the key so far as delay determination is concerned. And SCL Delay and Disruption Protocol talks about 6 methods of delay analysis. Most frequently used for a completed project is as planned versus as built method of delay analysis. This is what this is why. Otherwise, what happens? I have come across big arbitrations where I either sit as arbitrator or as counsel. I have seen parties without having benefit of the pseudo experts or ghost experts, sometimes you call it. You come out with your pleading, you say these are 10 delay events caused by the employer which has caused delay to this project for 49 months. But when you have employed a delay expert, when delay experts go through the documents and try to understand what was the critical path, what was the critical delays on a particular day. Suppose he is doing this critical delay analysis by following APAB method. First thing what he does is, he will determine the critical path by contemporaneous method, and he will tell you on this particular day of this project, this is what was causing the critical delay, this was coming on the critical path. Now, what happens if there is delayed appointment of an expert? You will be in a very anomalous situation. Delay events appointed out by you are in complete conflict with what was the actual critical delay on the project. So you need to avoid this. So these are some of the thoughts I thought I'll share with all of you. And another thing, I have just talked about delay and disruption, and I can see Justice Gupta getting upset with the way things are going. So some anxiety I can see in my chair. Not so it was on lighter side. I said anxiety. So therefore, I don't wish to go into how to ask for extension of time and how to do. First of, and I conclude by saying anybody and everybody having anything to do with construction dispute or construction arbitration, try to have SCL Delay and Disruption Protocol on your bedside table. That should be your CPC. That tells us what is critical delay, what is record keeping, what is acceleration, what is float, what is bonus, and what is all about this whole industry of construction law. Thank you very much.
Well, thank you very much, Ratan, for that great presentation. Thank you, Mr. Chairman, for chairing today. And thank you, everyone, for being here on a Friday afternoon. I'm conscious you might be doing other things, such as seeing session 4B, or perhaps, moreover, witnessing my fellow Australians being slaughtered at the cricket here in Delhi, all out for 263, I think it was. Now, we're talking about delay, and to try to contextualize things, I know that the title of this session is to do with the Asian perspective. Well, it's probably more of an international perspective that you're going to get today. Let's try to understand delay and how it works in a construction context, because delay isn't necessarily a universal thing. It's common, but not universal. So let's start with this particular slide that you can see here. It's got quite an interesting photograph and headline. So that the headline is, Chinese construction firm erects 57-story skyscraper in 19 days. Now, that must be a record of sorts. There's no delay there, no messing around. I'm not sure what the quality was like with this particular building, but it was certainly built very, very fast. Now, that's at one extreme. But at the other extreme, we have projects that can take a little bit longer. So some of you will recognize the building you see on this slide. It's a church in Barcelona. It's called the Church of the Holy Family. They broke ground in 1882, and they're still working on it. Practical completion is due in perhaps 2026, give or take a decade or so. So that's something at the other end of the spectrum. But taking those two extremes, what's the norm? What are we generally talking about when it comes to construction projects and the time that it's taken to complete them? Maybe this gives a flavour too. This is a headline from a UK publication, the Architects Journal, from a few years ago. And you can see it there, hopefully. Almost 2/3 of projects were late in the past 12 months. That's the headline. And beneath that it says, a staggering 60% of projects were delivered late to clients over the past year, according to new data. So that's telling us, if that's representative, that, okay, not every project finishes late, but a fair proportion of them do. And I think for those of us who work in the construction world, the construction and engineering world, we know from experience that delay is a very common issue. So perhaps we need to ask, why is there delay? What are some of the main causes of delay? And I don't have any direct wisdom or experience myself, but we can do better than me guessing it and go to some helpful information which comes from the Royal Institute of British Architects. They do a survey in the UK every couple of years, and they ask people in industry various questions. You may not be able to read this particular slide unless you've got very good eyesight. I'll help you. The question that this data is addressing is this. During the construction phase of the project, which, if any, of the following matters impeded project progress during the past 12 months? So they're asking people what was causing delay to your project during the past 12 months. And this is the bit that really tests one's eyesight, including my own. There are a number of causes here. I won't go through all of them. I'll go through the top 4. So number 1 is employer's variation. The employer has instructed that something be done differently, new work, different work. That's going to cause delay. That's the number 1 cause. Just behind that, and bearing in mind the survey was done in 2021, 2022, this is a newcomer. Number 2 is COVID and COVID safe working practices. That has been a major cause of delay, as we know, around the world in relation to construction projects. And in terms of risk allocation and responsibility, COVID is fairly neutral in a sense. It's no one's fault. No one caused COVID, employer or contractor. But the allocation of risk could be either to the employer or to the contractor in respect of COVID delay. The third matter is required construction of products not being available. So supply chain issues. We all have read about and perhaps have experience of issues with getting necessary goods, materials for projects. China has been a big bottleneck for various reasons in relation to construction products. And again, on the risk allocation side of things, this tends to be more of a contractor risk, because the contractor is responsible for procuring materials. And the fourth one, and this is the last one I'll look at, is slow pace of construction. The contractor was slow, or slower than it should have been. And that's clearly a contractor risk. The contractor was running late. So what does this tell us? Well, it tells us that the top four causes of delay, certainly in the UK, maybe this is true elsewhere, are matters which are, as a matter of risk allocation, they could be on either side, employer risk or contractor risk. But what that then means is that if we finish up in a situation where a project has run late, it's gone over time, there could be multiple causes of delay. And so the task for those of us who work in construction arbitration is to try to disentangle those causes and to work out, well, what was the true cause of delay? And that's not always a straightforward matter. So to try to tease out those issues and see how they can emerge in a real world scenario, we've got a hypothetical scenario that we're going to work through just to get you maybe thinking about some of these things if you don't engage with them on a regular basis. So in a hypothetical project, we have a roads project in the kingdom of Xanadu. It's a mountainous sort of a place. And what are they doing for this project? Well, they're building a motorway segment. It's 25 kilometers long. You can see it there. And because it's a mountainous place, that there's a need for a tunnel, a 2-kilometer tunnel. So 25-kilometer motorway, 2-kilometer tunnel somewhere along the motorway. That's what the project is about. The contract form is a FIDIC Pink Book. This is the MDB harmonized edition, as it's known, a Pink Book for short because of the color. This is a form of contract for those who may not be too familiar with it. It's used in projects which are funded by international agencies, including the World Bank. That they tend to favor this particular form of contract. And I read it in brackets that the World Bank is looking for a new president. So if any of you here are thinking of applying, sharpen up your CVs. Right, so that's the contract form. What does the contract itself say? Well, we have a few facts we've scattered in here. Where is the contract entered into? The 1st of November 2019. That's quite important in this particular context. The contract is subject to English law, and the time for completion, very important, it's stated to be 24 months. So 24 months from when the contract is signed, which takes us up to 1 November 2021. Contract price, $100 million US, and as one might expect, damages are payable if the contractor is culpably late in completing the project. Damages are $100,000 US per day, but they're capped at 10% of the contract price. They're capped at $10 million US. That's the contractual setup here in this particular scenario. Let's now explore what happens once the contract's signed. Well, the contractor gets to work, and it starts by working on this tunnel. Remember, there's a 2-kilometer tunnel the contractor has to construct here, and it's using rock blasting techniques to build this tunnel. But what happens? Well, shortly after work starts, there's a problem that someone discovers. What's the problem? Well, it turns out someone made a mistake, and the tunnel was being excavated or blasted in slightly the wrong spot, so that they had to abandon that particular area of work and then go to the right spot and start working on the tunnel, blasting away. Now, as you'd probably expect, this error, which is the contractor's responsibility, is going to cause delay to the tunneling works. And in the contractor's estimation, the delay will be a period of, say, 2 months. caused by this particular mistake. So that's the first thing that goes wrong, but then it gets worse for the contractor because shortly thereafter, going from February to March 2020, COVID appears in the kingdom of Xanadu as it spreads across the world. So what does the government of Xanadu do about this? Well, it takes what was a fairly conventional approach to dealing with COVID. It passes laws on social distancing. It restricts the movement of people and the movement of goods. And for a period, it actually it orders that construction sites be shut, including this one. Even though it's mainly outdoors, it's shut down for a period, and then it reopens in May 2020. But the workers have to socially distance and so forth on the site. So this has an impact too on the contractor. And remember, this affects the whole site, the whole road project, including the tunnel. And at the time, the contractor estimates that the COVID delays will be in the order of about 3 months. They'll lead to 3 months delay in completing the work. And as I said, it affects all sections of the project. So what does the contractor do? Well, it claims an extension of time under the contract. It says, I need the extension of 1 November 2021 as the completion date. That has to be pushed into 2022. But the engineer who deals with the extension of time application rejects that application. Says, no, you're not entitled to an extension of time. Yes, you're running late, but you are running late because you made a mess of the tunnelling works. So that's why you don't get an EOT. So that's what happens back in 2020, but we need to move forward to the end of the project. So the work largely proceeds thereafter okay, but the project finishes late. It finishes 2 months late, on the 1st of January 2022. And then the parties sit down and they try to work out, well, who owes money to whom. Now, the employer says the project's late due to the contractor's fault. The contractor made a mess of the tunnel, caused delay, and that explains why there's this 2-month delay to completion of the project. The employer then says, consistent with that, the project was 2 months late, I am entitled to 2 months of liquidated damages, which at 61 days times $100,000 is $6.1 million. Now, the contractor for its part says, no, I'm not accepting that. That's not right. That is not why the project was late. It was late because of the COVID situation. I was due an extension of time for completing the whole project, which wrongfully was refused. So I'm not liable to pay liquidated damages. So that's how things finish up on this project. And that poses a number of legal questions for us, which is, well, how does the law look at this situation? We put on our legal goggles, what is the answer here as between these particular parties? And in order to understand what the legal answer is, we need to understand what the law says in relation to matters of delay under construction contracts. And certainly as a matter of English common law, the general approach is very clear. And the approach that the law takes is one of freedom of contract. I think that's what George Michael was singing about all those years, wasn't he? And this is the idea that if competent people enter into contracts with their eyes open, they negotiate terms or whatever, they're bound by those terms. And it's the role of a court or an arbitral tribunal to give effect to those terms, as the parties have agreed. Now, what does this particular form of contract have to say in relation to delay and extensions of time? And we're talking about extensions of time here. You may be able to read this. The relevant subclause in this FIDIC contract is 8.4. This is the 1999 FIDIC, not the 2017 FIDIC, by the way. So what does it say? Well, it says, the contractor shall be entitled, subject to giving notice, to an extension of the time for completion if and to the extent that completion, ... is or will be delayed by any of the following causes. So, and what are those causes? Well, they're listed out. It's like a shopping list of matters that entitle the contractor to an EOT. Number one is a variation. So the employer instructs something which is different from what the contractor is obliged to do. B is a cross-reference to other provisions in the contract. C, exceptionally adverse climatic conditions. It rained a lot. The works were flooded. Is that exceptionally climatic conditions? It could be if you're in a desert environment, but maybe not if you're a tropical environment. Who knows? But now let's get to the most relevant subclause, which is D. Unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental action. So we had unforeseeable shortages, yes, COVID came along, no one foresaw that back when the contract was signed, in the availability of personnel or goods, people couldn't work, goods couldn't be brought to site, caused by epidemic, COVID's an epidemic, or governmental actions, that too. The government of Xanadu shut construction sites, imposed social distancing laws. So tick, 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 tick. We're ticking all the boxes here, it seems. So that's good for the contractor as a matter of entitlement. And subclause C is prevention by the employer. So that's potentially good news for a contractor in this situation. It has a basis potentially to claim an extension of time. And of course, that's what the contractor here did when COVID emerged in March 2020. But this then begs the question, if we're looking at things from a legal perspective, how are extension of time applications to be assessed? Well, again, remember this concept that George Michael was singing about freedom of contract. It's what the contract says. What does this contract say about EOT assessments? This is what it says. It's subclause 3.5. Now, the first part says, well, the person to whom the EOT application is made, the engineer, is meant to try to get the parties to agree. That rarely happens in practice. If that doesn't happen, there's no agreement, we need to look at the last sentence. It says, if no agreement is achieved, the engineer shall make a fair determination in accordance with the contract, taking due regard of all relevant circumstances. That's what it says. That is what the engineer is required to do. And just looking at those words, fair determination, due regard, all relevant circumstances, they're quite vague, general words. They're not requiring that EOT applications be dealt with in a fairly precise or defined way. But what do these words mean? A court or an arbitral tribunal has to give effect to them. So we need to understand what the words mean. And so what is a fair determination? That's what the engineer has to do. And there hasn't been much judicial consideration of this matter, but I think as a matter of language and as a matter of general understanding, we can say what it is referring to is someone doing their best on the material that's presented to them, that is assessing the EOT application, acting in good faith. And this could mean, for example, that if an EOT application has been submitted by a contractor and the engineer senses, actually this is a good EOT claim, there should be a good basis for this claim given what has happened on site, but there's not enough information, well, the engineer should request more information from the contractor in order to make a fair determination. What the engineer shouldn't do is simply reject the claim and say, well, you haven't given me any details, so no EOT will be given to you. That's what I think this particular clause is calling for. Even if we're talking about a contract operating under a legal system, such as the English legal system, which doesn't embrace good faith as a general doctrine. And I want to now move on to a consideration of this type of clause, this type of EOT clause generally. And now when you look at the slide, you might think, what on earth is he going to say now? Is he a complete madman? Why has he got a guy with a gun on the slide there? I'm looking at non-prescriptive EOT clauses that require a fair and reasonable EOT and how they work. Now, can I ask a question for those who are here and maybe those who are at home watching on YouTube even? You can send a message if somehow. Do you recognize the gentleman holding the gun? Does anyone here recognize him? Hand up. Yes, sir. Kalashnikov, correct. There's Lieutenant General Mikhail Kalashnikov holding a version of the gun that he invented, the AK-47. And the story of the AK-47 is actually quite interesting, I think, and instructive here, if you'll bear with me. So how was this gun invented? Well, at the end of the Second World War, the Soviet army did a review of things, including their weaponry. And they realized, although they won on the Eastern Front at great cost, they realized that the Germans had better guns than them. So within the Soviet army, they decided we're going to make a new gun, and it's going to be a good gun that we can use throughout the whole army. And they had a competition. And so various people submitted their prototypes for guns. And the winner, as you can probably guess, was Kalashnikov. Now, the thing about the Kalashnikov is if it shoots at the target, it might hit the bullseye, the number 10. Okay, I've been told to conclude. Actually, I think it's a truism that every presentation about delay runs over time. So I'll try to wrap up soon, Mr. Chairman. Thank you. The Kalashnikov would hit the bullseye once or twice, but then it would spray around the target and hit the other areas. Yet there were other prototypes that were much more precise, and they hit the 10 again and again and again. And yet the Soviet army chose to go with the Kalashnikov. And you might think, why do they do that? Why would you choose, as the gun that the whole army is going to use, this less accurate weapon that hits around the target but rarely hits the middle? And the answer is this. The Kalashnikov was and is a simple weapon, simple to make, simple to assemble, straightforward to use, and moreover, it could be used in all sorts of conditions and it would work. It could be hot, it could be cold, snow, dusty, rainy, you name it. The gun would be reliable. Whereas these prototype guns, these other ones that were more accurate, they could hit the target, yes, but at the firing range. But as soon as you took them out into the desert or somewhere like that, they'd seize up and be completely useless to the soldiers who were holding them. So what was decided here was the weapon that is most useful in the field is one that works, that people can use. And in taking this into our EOT construction context, we have this vaguely worded EOT clause that requires a fair and reasonable determination. No precision is required here from the engineer. The engineer just needs to ensure that if a valid EOT claim is made, the assessment hits the target. That's what the clause is calling for. It's not calling for precision. And consistent with that, remembering this type of clause has been around for more than a century and is still used, let's consider briefly how EOT claims were dealt with in what I've called the good old days. And this is one example from 1915, a case of Matsoukas and Priestman in England. It was a project to build a ship, which was meant to be delivered by the 28th of February 1913. There was an EOT clause in this particular shipbuilding contract. It said, among other things, that the shipbuilder could claim an EOT if there was a workers' strike. Now, there was a workers' strike. There was a national coal strike in England in 1912. That affected this particular shipyard. And so the question, there was a dispute over this, and it went to court, and it was put to a jury. And so the question was asked of the jury, what was the delay to the shipbuilder? And the jury came back with an answer. Said, well, the delay was 70 days. No reasoning, nothing. That was it. That's all the jury had to do. So this very imprecise way of dealing with this EOT application. Now, that was in the good old days, but what about now? We've got more modern technology. We have computer software that allows us to project critical paths and to come up with what might seem to be a very precise answer to the question, what EOT is the contractor due? Now, we do have this excellent software, and maybe we can take advantage of it, but we need to understand where this fits in the picture. We might get what seems like a precise answer, but what an EOT clause like the one we're looking at is after is a fair and reasonable determination, which may involve looking beyond the computer for the answer, which means when we're looking at things like our situation, our factual situation, where we've got the two delays, COVID and the tunnel error, and maybe they have an impact at around the same time, we need to ask the question, well, what does this mean? How does that affect the determination of the EOT under this broadly worded EOT clause? And I hopefully not run too late, sir. I'll conclude there and hand over to David Thomas of King's Counsel, who will, I think, give you some of the answers to those questions. Thank you very much.
Well, hi everybody. It's a pleasure to be here, and thank you very much for coming to a construction law seminar or symposium late on a Friday afternoon. Well done. Now, I'm going to try and get back to the scenario and explore with you what the answer to it might be. but I'm asked also to just say a little bit about presenting a delay case, how we go about the advocacy and how we go about the evidence, and then we can think about how we might try and persuade a tribunal of one answer or the other in relation to our scenario. So I'm going to start by looking at these headings when we come to think about presentation. The pleadings come first. I think I'm talking to an audience of lawyers here who may be acting for contractors or employers. I'm talking really here about good practice in presentation before tribunals, so drawing on my experience of international tribunals or in my younger day, the English courts. So the pleadings come first, and I think it's really valuable to persuade your clients, be they employer or contractor, to invest in making a good job of the pleadings. It is a lot of work at the beginning, but it's worth it. Get the basics of your case straight and agreed between your team, yourself and your client, and get your experts involved at the outset. It really will help you through the course of the arbitration as it develops, perhaps over 18 months or 2 years. If you start with pleadings that are not thought out and are muddled, you will be forever disadvantaged, I promise you, through the rest of the case. You will be vulnerable to attack from the other side. You'll never quite know what your own case theory is. So persuade your clients to spend up front on that. And one thing in that, if you're doing a delay case, plead a case not just on liability, but on causation. Again, whichever side you're on, get the key facts set out. This is what caused the delay. This is the clause of the contract that we are claiming comes within, so it's an employer's liability. This is the activity that event delayed by this much, and the effect of delaying that event was to delay completion, and explain how that happens. And get the money sorted out at the beginning as well. If you're on the other side, get your criticisms sorted out. Good idea at the beginning to work out where the money went. You're trying, if you're a claimant, to get money for your clients. So, which are the most valuable variations? Which delays are most valuable to you? It's not necessarily the longest delay that'll give you the most money. Contractors' costs tend to go in a sort of bell curve, roughly, as the project proceeds, starting fairly low because there's not much mobilized, not much procured, building up, and the highest costs tend to be in the middle of the project, and then they wind down. So a short delay in the middle of the project might be more valuable to your client than a big delay at beginning or end. So bear that in mind, think tactically in working out what your client's best case is. Now moving on to liability then, what Julian didn't tell you, and I think he's got a bit of contractor bias here maybe, is that contract has got this clause in it. And these types of clauses are very common in sophisticated construction contracts used internationally, and I don't know, you may see them in India as well. But look at this, the claiming party shall give a notice, cross-reference, got to be in writing, as soon as practicable, and no later than 28 days after the claiming party became aware, or should have become aware, of the event or circumstances, that should be or. If that party fails to give notice within this period of 28 days, the claiming party shall not be entitled to time or money. Very important clause. What are we going to do about it? On the face of it, it looks like the employer is going to rely on it, and they do. They take every advantage of it that they can if they can say there's no notice in time. As a contractor, you're trying to bring yourself within it, say we've given notice. But let's stand back and have a think about this clause. Let's assume that the employer is responsible for delay. Let's assume that the COVID situation, if you like, that's his risk. Let's just assume that the contractor didn't give a notice. Might be something more extreme. Employer denies access for a couple of months at the beginning of the project, and contractor doesn't give a notice. The analysis shows that the employer's delaying event was critical. It did delay completion, but because there's no notice, he's going to turn around at the end of the project and say, you were late finishing. It was because I didn't give access, but you didn't give a notice. So you're liable for those 2 months delay, and I will have my liquidated damages for those 2 months, thank you, because of your failure to give notice. Is that fair? Right? Well, different legal systems will give you a different answer to that. If you're in civil law jurisdictions, and for example, the Middle East, where I go a lot, these clauses will be struck down in principle because they offend principles of good faith, which are extremely high profile in the Middle Eastern jurisdictions. The common law upholds these clauses in principle. So if you're in a common law jurisdiction with your contract and you're in trouble on notices as a contractor, you're going to have some tactics to get around it. You might want to think about the wording of the clause. When did the claiming party become aware? You might be able to say, I only became aware at the beginning of the arbitration when my expert told me that that was a delaying event. So I didn't have to give a notice until my pleading, when it's in my pleading. So it might be saying things like that. So you've got to focus on the words to see how that applies. Maybe you can get out of the problems like that. Or you may want to use the doctrine of Aristotle to say, well, this project was never run on the basis that anybody cared about this notice procedure, and we all understood the convention of this project. But look out for that. It's a very prevalent issue in construction contracts. The rest of liability, obviously, you've got to work out as claimant where you are under the clause. You've got to establish that event is within it. Relatively simple in our scenario, and Julian's done that. You might, though, to get yourself within a relevant subparagraph of an EOT clause and make it an employer event, or resist that if you're the employer, you might well be needing expert evidence because there might be technical questions involved in that. Is something a variation, for example? Is it within or without the technical specification scope that the contractor was responsible for? Is there a breach? What about climatic conditions? You might need expert evidence on that. So technical evidence might be needed to establish liability for the event in question. Just going back to liability, one common mistake for claimants, made all over the world, frankly, in running claimants' delay claims, is to over-focus on liability, thinking, right, we've got a great claim here, it's a massive variation, it obviously caused lots of delays, and going into great detail about and telling a great story about all of that and lots of evidence about it, missing the real point that is so often at the heart of delay cases is, did that actually cause delay to completion? And those are the facts that matter, establishing that delay, it might be a small thing, causes a lot of delay, or it might be a big thing, causes a lot or a little, but that's what you've got to establish. It's the causation case that is so often neglected by claimants, and it leaves them very vulnerable to respondents attacking it. Respondents too, if you're a respondent, very important tactically, if you want to be persuasive in front of a tribunal, get a positive case. Explain your view of what happened over the course of the project. Don't just let the contractor set the agenda and you just saying, no, no, no. You say positively what you believe happened, and it gives you a much, much stronger position. But this is critical to focus on causation, and it's causation that the completion date was delayed. It's not just that the activity was delayed, it's that completion. That's what the clause said. And how do you go about showing that? You'll hear a lot about experts, delay experts. They are important to the presentation of both parties' cases. They do play an important role. But my experience throughout has been that if you really want to persuade an international tribunal that you are entitled to an extension of time, or that the contractor is not entitled, then the persuasive way to do it is through the facts, through the factual witness statements, and through the documents. The most powerful way of supporting your case is to get a witness statement from somebody who was on site and knows what's happened, get them to do a thoroughgoing chronological witness statement referring to and reconciling with the contemporaneous documents, explaining that they're wrong if necessary, but telling a story. A delay case, the course of a construction project is a story, and that's what the tribunal will want to hear. So start to think there, work with your experts, certainly, in working out what that story is. They have a role, but they are secondary, in my view, to the factual evidence. And there is a theme to everything I'm saying, and I think it's reflected in my co-speakers' speeches as well. This is all about facts. Delay is a question of fact. Now, so tell the story in that way. Role of expert evidence, then, what is it? Yes, it is really important in delay cases. You need a good delay expert. But the role is, in a sense, supportive and analytical. So you will want to work with your delay expert. You will want him to be validating your client's positions. If you're a contractor, for example, or employer, you will want him or her to look at the contractor's first program. It might be called the contract program or the baseline program or contract Rev 1 or whatever it's called. That's the sort of as-planned program. Get that reviewed, get it ticked if you possibly can, if you're a contractor, or pull it to pieces if you can, if you're an employer. So if you can show as an employer that that was unrealistic, over-optimistic, then delay was baked into the project from the beginning. There was no realistic plan. So there's the first thing. You do need objective help from your expert in dealing with that. But what is the real heart of the matter for delay experts? Some people will tell you that it's not a proper expert discipline. Some people, certainly in the UK, are very sceptical about it, and certainly sceptical of computer analyses. I believe that you get out of a computer program what you put into it. So there is skepticism around. I think myself there is a genuine core expert discipline there, and that is actually identifying the critical path. Because it's not a simple matter to identify where the critical path, that chain of activities, that longest chain of activities that leads to completion, where it runs through complex works. And I think that is a proper subject of expert discipline, and that's what you really do need your experts' help on both sides. And there's often controversy about it. Where was the critical path at any particular time? So that above all, I think, is the focus for experts. And that will help you with your witnesses. Get the team working together on either side, so reconciling the more technical view of the critical path, perhaps with what the witnesses thought at the time. If you've got a project manager, he should have known where the critical path was if this was a well-run project. Ditto the employer's project manager. And by the way, one rule about witness evidence, the minimum number of witnesses on either side. If you have lots of witnesses, cross-examiner will get them to contradict each other, say different things about different documents. So if you've got one project manager who covered the whole period of the project, that's it. That's your guy or girl to deal with the delay story on either side. Minimum number, very important tactic. Now, I've got to be short because we are very short of time. The experts have different methods of analysis, which Ratan touched on earlier on. The two big questions are, do you do it prospectively or retrospectively? A prospective method is where you start typically with a baseline program, the as-planned program, and you put the events in there to see the changes, and the computer will spit out a delay at the end. Now, if you're a contract administrator assessing an extension of time during the course of the project, you've got to do it prospectively because you're supposed to enable a contractor to have updated completion date. You've got to do it prospectively. People tend to be cautious because you don't know what's going to happen in the rest of the project. And that's the problem with prospective analyses. They can be so wrong because you just don't know what will happen later. Time might be recovered. Retrospective is what's going to happen at the end of the project and is therefore always used in arbitration. Even, I think, when you get contracts that actually say EOT is to be assessed prospectively. We've got one of those in very common use in the UK. Tribunals actually still look at retrospectively, because if you go back and say, after the project's finished, I've got to place myself in the position of being in the project and looking forward artificially from there, they just won't do it. It's ignoring the best evidence, it's ignoring the facts, it's contrary to principles for lawyers, and it gives you the wrong answer, probably give you a greatly overstated answer. Contemporaneous refers to the critical path, and in arbitration, the normal and good practice is to work out, as you go through the project, how the critical path moves. Start with a baseline, then as things develop, trace where the critical path is lying, and then look at what actually happened to work out the delay. That's the delay and disruption protocol, listing out the 6 different methods. I agree with Ratan, the one probably used in arbitration is as planned compared with as built. But I'll have to let you, I think, read the protocol on those. Do not be distracted by prospective methods if you are in arbitration for either side. The delay and disruption protocol, Ratan mentioned, it is a very valuable document, but it's not the law. It's not part of contracts. It is very important guidance on practice. So yes, I agree, make much reference to it. It's an enlightening document, but it's the contract and the facts of each individual case that actually matter. So yes, extraordinarily valuable resource, but not the be-all and end-all of everything. I'll skip over that next one and start coming back to our scenario. The delay and disruption protocol is helpful in guiding us as to where we're going to get to here. What we seem to have is concurrent delays because we've got COVID, which closes the project down, and at the same time we've got 2 months of delay because of the contractor's error with the blasting. What does the protocol say? True concurrent delay is 2 or more delay events at the same time. We've got that. One an employer risk, the other a contractor risk, and the effects of which are felt at the same time. For it to exist, each of the employer and contractor risk events must be an effective cause of delay to completion. Note that, effective cause of delay to completion, i.e. must both affect the critical path. And then this is the guidance, where contractor delay to completion occurs or has an effect concurrently with employer delay to completion, the contractor's concurrent delay should not reduce any EOT. So if we've got concurrent delay here, and they both do cause delay to completion, then this guidance is saying the contractor still gets his EOT. Now, to be clear, and this goes back to what I was saying about the protocol, it doesn't get that because the protocol says so. This is not the law, and it is not a contract. It is guidance. It happens to be guidance that accords with the common law. But that's all. Moreover, go back to Julian's point, the common law is all about freedom of contract. So that rule, or that principle, can be overridden by the contract. So you can't be sure, you must go back to the contract always. That defines the party's right. I'm being asked to conclude. So you must go to the facts. Now, I will try to conclude, therefore, by just going to see where we were on our scenario. The work on the whole of the road has got to be critical. If you just close the whole of the works down, I mean, you're very likely to cause critical delay. So let's assume that we do. But what's the answer? It depends on the tunnel. Now, with typical lawyer's insight, I'm going to have to say that the answer depends. It all depends. And back to my overarching theme, it all depends on the facts. Now, that tunnel might or might not be critical to completion. A delay to the tunnel might or might not. And this goes back to the Honourable Justice's point at the beginning. That delay might or might not delay completion. Let's just think about it. This was going to be a 2-year project. The tunnelling works were 2 months delayed. Why did it, were only 2 kilometres, 2 kilometres out of 25? Who says that the tunnel works had to be done at any particular point, that they had to be done at the beginning? Why can't they be done later? So that's what the contractor will be trying to say to the tribunal. I'm saying, Mr. Tribunal, I could have done them any time. And then, of course, by then we'll have the facts. When did they do them? Maybe they fitted in nicely. Maybe they did actually cause a delay. So you've got to look at the facts that actually happened. The employer, conversely, is going to try and persuade the tribunal that this was a critical delay, so that there is concurrent delay. Why might that be? Well, take a sort of very simple fact. supposing you've only got to access one side of where the tunnel is going to be, and you've got to get through the tunnel to the other side to build the road the other side. Well, if that's right, it must be critical. So we're almost certainly going to have concurrent delay there. Now, if there is concurrent delay, it's going to change things financially, because the rule there is, as we've seen, the contractor still gets its extension, and so that means no liquidated damages, but the rule is that if there is concurrent delay, the contractor doesn't get prolongation costs, the reasoning being that they were going to be incurred anyway, so there's no actual additional loss. So that's the effect of doing that. But bear in mind, this I think my last point before my last slide, employers around the world, certainly sophisticated ones, do not like this rule. They do not like the fact that they can lose their entitlement to liquidated damages when the contractor is responsible for some concurrent delay. That's the rule. That it looks fair, neither side gets money, as it were, but employers don't like it. They say, right, well, the contractor did cause delay, I should have my liquidated damages. And you do find what are called, in the jargon, concurrency clauses written into contracts more and more these days to change the basic principles approach and to say if there's concurrent delay, the contractor is responsible for that delay. That's a contractor risk, and so liquidated damages would flow. So watch out for that. As an employer, you want something like that. As a contractor, you sure don't. And final slide, just a word about compensation. I'll come back to the head office point, formulas that previous speakers focused on. Absolutely agree. You do need a good quantum expert in at the beginning and collating all the documents for you and collating the myriad of financial claims that there will be. It's complicated on a major construction project. It always is. There's masses of documentation going into lots of detail, like timesheets and so on, and years of it, or at least there should be such documentation. If there's not, you need an expert even more. It's a very important role. Formulas are okay, I agree, purely for quantification, but you've got to prove the facts. You've got to prove as a contractor on a balance of probabilities, I would have won these other projects, and they would have returned me some overhead recovery, they would have made me a profit. So what tenders were they offered? What invitations to tender did they get? What did they do about them? And so on. What's their history of such things? As an employer, you want to rip that to pieces. Go through the accounts and show that they didn't do well on when they got invitations to tenders. They didn't actually conclude many contracts out of that. Look carefully at what type of contracts they might have been, what sort of profit and overhead recovery was made of those. So you're drilling into the detail on both sides. Again, it's the facts, and that's how you do well in a delay case. You get a coherent, clear explanation of the facts from beginning to end. Now, there was supposed to be time for questions, but I think we may have had a little critical delay, but I'm in the hands of the Honourable Justice.
Audible. Yeah. Thank you to all three of you for a wonderful, very illuminating, presentation. You worked as well as the Indian cricket team is working nowadays, and the delay that you have caused is that I can't allow any googlies to come from the other side. But many of my questions, many of my issues which I had raised and I had flagged at the beginning have got resolved. And for a few, I'll have to buy Julian's book and also the protocol. And I think it's been a very interesting experience. I, for one, have learned a lot during this session. And thank you all. Thank you, David. Thank you, Julian. Thank you, Ratan. I think we'll have to call it a day.
Apologies, we'll not be able to take questions. We've already exceeded time. But that was quite an enthralling session. Thank you all the speakers in the chair. And with this, we come to the end of today's program. We'll see you all tomorrow at 10 a.m. and assure you that it'll be as engaging as today. Thank you.
No, but it was very interesting. I for one.
Seventh floor. We request you. It's not working. Hello. We request all of you to please join us for high tea at the 7th floor.
I'm sorry for.
No, I know. I mean, I didn't start. So it was,
I hope you're feeling better now.
actually, having to make a speech makes you feel better. So the adrenaline takes over. So just at the moment, I do. Oh, thank you very much. That's very
One. Delete per doing. Delete per.